Good morning, and thank you for joining us. We are so excited to have Jennifer Richards here from Safety Matters, and she's going to be talking about HEC. So hopefully that's a good topic, and it cracked me up when I saw it, and I think I sent out the what the heck email this morning to get some attention, and I'm glad that you're all joining us. As the webinar goes on, as usual, just put all your questions in the chat box. And when we get to the end, I will pop back in and we'll go over the questions with Jennifer and she'll answer them. I also have a handout for each one of you that I'd like to email to you. So shoot me an email at Tracy, T-R-A-C-E-Y @rcaw.com, and I will get that to you right away. All right, well, I'm going to turn this over to Jennifer, and thank you for joining us, Jennifer.
Thank you, Tracy. Hi, everyone. I don't have my camera up, but I'm hoping everybody can see the screen. And as Tracy mentioned, just hang on to your questions until the end. I'm going to rush through some of these first slides. But if you want this PowerPoint or you have, or the handout isn't enough, it's basically a summary of this PowerPoint, just shoot me or Tracy an email and we'll get you whatever you like. Just a real quick background on me. I was in construction for about 12 years as a concrete carpenter from 87 to 99. And then I was the safety director for a large general contractor in the area. And I got into the retro side of the business for a while at Approach Management Services, and then left in 2008 and started Safety Matters. So over the years, I have had a lot of dealings with labor and industries and went to a lot of Board of Appeals and informal conferences, and kind of through School of Hard Knocks, I've learned what the department needs to prove, for lack of a better term, in order to issue a citation. And so I'm going to start by kind of talking about what an employer's responsibilities are as far as providing a safe and healthy workplace. And then we'll go on to what Tracy was mentioning, HEC, which is an acronym that L&I uses to in order to issue a citation. So here we go. All right, who is responsible for your safety? I say you are, but as an employer, you're also responsible, obviously, for your employees' safety and health in any place of employment, obviously not just construction. So this is the Washington Administrative Code that basically says that an employer needs to furnish an employee a place of employment free of recognized hazards that could cause or are likely to cause serious injury or death. So that's kind of common sense stuff. No employer can require an employee to go or be in any employment or place of employment which is hazardous to the employee. And then it's the management's responsibility to make sure that your safety program is effective in practice. And we'll talk about that more as I go through the PowerPoint. Provide a safe and healthful work environment, create an accident prevention plan, or some people call it a safety manual. And we know the term site specific, which I'll talk about a little bit, and then provide training to meet the tasks that your employees are asked to perform. So for example, fall protection for roofers, CPR first aid for foremen, things like that. Okay. And then employees are required to apply the principles of the accident prevention plan in their daily work, follow the proper procedures, wear the personal protective equipment, use the safety devices that the employer provides. An APP, that's what I'll refer to the accident prevention program as. An APP is basically a formal program tailored to the needs of the particular plant or operation and the type of hazard involved. So this is where the term site-specific safety plan came into play. A general contractor along the way probably, created that term. You won't find site-specific safety plan in the Washington Administrative Code, but basically a contractor is required to create an APP and then tailor that APP to each project, which we now deem as the site-specific safety plan. Things that are included are route to nearest hospital, address, contact information, things like orientations and so on, fall protection plans, that sort of thing. And again, I'm kind of rushing through this because it's a lot to cover in 30, 40 minutes. One of the things that we do to meet site-specific requirements is we all provide orientations. Oftentimes, the general contractor will provide the orientation, but if not, and the general contractor says that the subcontractor is responsible for orientation, then that would be the subcontractor's responsibility. Labor and Industries basically just says employers have to do this, but general contractors can take control of that, which is more common than not. And subcontractors can attend the GC's orientations, and that will meet the orientation requirement. These slides basically cover what has to be addressed in the orientation, and I'm not going to go through all of it, but reporting injuries, reporting unsafe conditions, what PPE is required, proper actions to take in the event of an emergency, identification of hazardous gases, chemicals, things like that. So orientations, safety meetings, inspections, job hazard analysis, fall protection plans, daily pre-task plans. These are all examples of what makes an APP site specific. So you're probably very familiar with having a GC request a site specific. If you sub out work, you need to request a site specific from your sub tiers as well. So keep that in mind. You're basically viewed as like the general contractor if you sub out work to lower tiered subcontractors. Okay, so if Al and I were to drive by this situation here and they see some workers up on a roof without fall protection, this would be considered imminent danger, which would prompt a compliance officer, an L&I compliance officer, to stop and probably enter the site and do what they call opening a conference, or starting an inspection. They call it an open conference. Okay, so why would L&I visit your project? Number one reason would be imminent danger, which was the slide that I just showed you. The CSHO stands for Compliance, Safety, and Health Officer. They drive by, see workers on a roof without fall protection, they're going to enter your site. When they enter your site, regardless of why, whether it's a referral or a complaint, imminent danger, you've reported a hospitalization or a fatality, or it's just a random visit, when they do this, they are required to introduce themselves, show their credentials, usually a business card or a badge, and tell you why they are on site. If it is a referral or complaint, let's say an employee files a complaint because you didn't provide the appropriate PPE, or a resident complains about too much noise or something, you have a right to ask for that complaint, and it will most likely be anonymous, but you do have a right to ask to see the complaint. And you can refuse them to come on your site. I can tell you that most attorneys would discourage this. If you refuse their visit, they will tell you that they can get a warrant, and they most likely will go get a warrant, and they will return. My advice is you just cooperate, let them on site. Make sure you'll notify the GC that they've come on site if you're working for a GC. And don't refuse their visit. You're just going to make them upset and probably cause more harm than good. But it is your right to refuse. Or they might just show up randomly. The average random visit is like once every 7 years is what they say for the average visit. But obviously in construction, they tend to visit more because the hazards are more, you have more exposure. They don't go into a manufacturing plant very often because they don't see what's going on when they drive by. So and there are more hazards obviously on construction sites. So it seems like L&I has a stronger presence in construction than like manufacturing or general industry. Okay, so If they come on site, what do they have to prove in order to issue a citation? This is where the acronym HEC comes in. H stands for, is there a hazard? So you see, they drive by, they see a couple of guys or employees up on the roof without fall protection. The roof's over 10 feet, whether it's a steep roof or a low sloped roof, there is a hazard. The risk of falling is there. Is there employee exposure? Of course, that's the employee exposure. The guys could fall off the roof. Is this a code violation? Absolutely. Again, if that roof's over 10 feet, there has to be fall protection. Roofers do have some exemptions with using warning lines, and they can use like an attendant and that sort of thing, a safety monitor. And I'm not going to get into that today, but there are some exemptions, but for the most part, you would have to provide some kind of personal fall arrest system or be able to show that you have a safety monitor with a warning line system and so on. If you don't, is that a code violation? Absolutely. Employees are required to have fall protection, again, if it's 10 feet or more. This is the tricky one, guys. Does the employer have knowledge? Unfortunately, if you own the company and you've got 6 or 7 jobs going on, obviously you're not on all 6 or 7 jobs. And so you're having to rely on your foreman or your lead or whoever you have designated as the competent person. And that competent person is now in charge of that job. And it's sort of like they are a reflection of you, the owner. And unfortunately, you can't use the argument of employee misconduct as, this is kind of hard to explain, but even though you didn't see it, or your foreman or a competent person might say, I didn't see it, man. I gave them their harnesses, I gave them their ropes, and I told them where the anchor points are, and we reviewed the fall protection plan, and man, I turned my back and they came back from lunch and they didn't tie off. That doesn't necessarily mean that you didn't have knowledge, unfortunately. And here's the other kicker. If your competent person is one of those guys up on the roof without fall protection, the argument of employee misconduct is out the door, because a competent person is viewed as an employer representative, not an employee. And so that's where you really have problems in your program, is if your competent persons are breaking the rules. So knowledge is the tough one. There's ways that you can protect yourself and probably argue that you didn't have knowledge, and that comes from documentation. Having the site-specific fall protection plan, reviewing it with your crew, having it signed off, showing proof of discipline if employees are found in violation, and having like the 3 strikes, you're out, and we'll talk about that towards the end of this presentation. So again, you need all 4 points in order for L&I to issue a citation. If they feel they have proved HEC, then they can issue a general violation, a serious violation, a repeat serious, or a willful. General violations are going to typically be lack of documentation. The guys are maybe tied off, but you don't have a fall protection plan, or you haven't been documenting your safety meetings or your weekly site inspections, that sort of thing. Serious violation is an unsafe condition that could result in injury. More often than not, citations are deemed serious. Again, general violation is typically a paperwork issue. Repeat serious would be they came on your site, you had another fall protection issue, and they looked at your history and saw that, oh gosh, this contractor got in trouble for fall protection a couple months ago or within the last 3 years, and now it could be a repeat serious. That's when the fines can get pretty hefty. And then a willful would be, typically it resulted in a really serious injury or fatality, and they can prove that the contractor willingly, knowingly put their employee in harm's way that resulted in a serious injury or, again, a fatality. I would say serious violations are probably the most common, but unfortunately with roofers and framers and siders, serious repeats can be common as well, because your most common hazard is going to be falls. And so lack of fall protection comes up a lot in these specialty trades like roofing, siding, and framing. So, and again, the repeat serious can get pretty expensive. Okay. So how do they calculate the fines and penalties? They look at two things: probability and severity. If you have workers up on a roof and they're not tied off and it's over 10 feet, what is the probability that the unsafe act could result in injury? They're going to look at things like, is it a steep roof versus a low sloped roof? How close are they to the edge? Is there any kind of protection? Is there any kind of a parapet or anything that might prevent them from falling off of the roof? That might lessen the probability. Then they're going to look at, what if they were to fall, what's the severity? If the worker's injured, what will the severity of their injuries be? Most likely it's going to be a high severity if it's an issue of fall protection. So they rate it on a scale of 1 to 3. So if a worker was observed working at or above 10 feet without a personal fall arrest system and the worker fell, it would most likely be rated a 3 for probability and a 3 for severity. That's going to give you the highest fine. It used to be 7,000 is the maximum for a serious fine, but it could be 7,000 times 4 workers, you know, so it could be 28,000 if 4 workers were up on the roof without fall protection. That maximum fine has increased. I don't know exactly what it is anymore, you guys. I'm trying to get that information. I had a sheet and I know I'll find it. I have a call into a consultant at L&I and I can find that out. And I'll get that information to Tracy for anybody who's interested, but it's well over 7,000 now. I want to say it's around 11,500 or something is the maximum. But anyhow, that's what they're going to look at: probability, severity, and then how many people are exposed. Okay, some other things they're going to consider is the size of the company. If you have under 25 employees in Washington State, not just on the project, but within your company as a whole, you're going to get around a 75, maybe 80% discount. Then there's a discount for like medium size, which is somewhere between 26 and I think 100 or something like that. And then 101 to 250 is medium large. And then when you get up over 250, there's no discount. So medium might be, I think it's like a 45% discount. Medium large might be like a 65. Don't quote me. I don't know the exact percentage, but they will discount the maximum fine for your size of company. Another thing they'll look at is good faith. Were you proactive? Did you address the compliance officer's requests and correct everything immediately? Or were you reactive? You know, were you being a jerk and, you know, questioning their authority or telling them that this is all a bunch of BS, you know? So having a good attitude and coaching your competent persons and foremen, the people who are representing you, you know, letting them know, hey guys, be respectful. They're just doing their job. You know, that's very helpful. And you'll get I think it's up to a 5 or 10% somewhere in there discount for good faith. Then the next thing they'll look at is history. Is this the first like violation within the past 3 years? They're talking about jumping this up to 5 years. They could go back possibly 5 years. I don't think that's become law yet, but it could be. There's been so many changes that have been proposed, and I'm not 100% sure if it's come into effect or not. But I know at least 3 years. So again, if you've already had one fall protection violation and now within 3 years it's your second one, you're not most likely going to get any kind of a discount for good history. But if it's your first one, there's a significant discount allowed typically. Okay. So can you appeal the citation? Yes, you have 15 business days. It takes about, in my experience, a month or so, maybe up to 6 weeks, depending on how busy the department is. Right now, they're very busy because of COVID, but they'll issue a citation. It will come in certified mail. And at that point, they will address every Washington Administrative Code that was issued the citation, and or that they reference to cite against. And then you have 15 days to decide if you want to go straight to the Board of Appeals or you want to go to an informal conference. A lot of people opt to do the informal conference first so that they can explain the circumstances. It's not in front of a judge, it's in front of an L&I hearing officer. It's very informal. You meet at their office, you sit around a conference table, and you explain the circumstances and ask for it to be either vacated or reduced, or maybe reduced from a serious to a general. I'm going to be straight up with you. I have not had a lot of success at the informal conference level unless it's the first violation. If it is your absolute first violation, you most likely will get some relief and they will lower the fines and penalties. Not guaranteed. If you don't want to go to the informal conference, you can go straight to the Board of Appeals. The department does not want you to do this. It costs them a lot of money to go to the Board of Appeals, and they would much rather try to settle out of court. But you can do that. Most contractors would hire an attorney in that case, and you go in front of a non-biased judge. It's not somebody that works for L&I, it's just a regular judge. Or there is also an option of mediation. You can hire an attorney. Typically, you would do this with an attorney and go to L&I. I've seen this a lot with willful violations, repeat serious, and they will basically, come to an agreement through a mediator, and your fines will be significantly less, but then you're most likely going to be on probation. So in other words, if you have another fall hazard and you're issued a citation with, say, 5-7 years, whatever the probationary period is, now you're dealing with multiple citations again, because those citations that were removed through mediation are going to come back on. Kind of like, if you go, I can't remember what the term is, if you get a DUI and you say, hey, I want to go, you go deferred. If you get another DUI, you're going to be dealing with both. So that's the problem with mediation. You have to really trust that your employees are going to walk the talk. So be careful if you go to an informal conference, because everything that you say in an informal conference, if you don't like the outcome and you decide to go to the Board of Appeals, everything in the informal conference can be used by the department in the Board of Appeals. So the informal conference is recorded. They tape record everything. So just, be aware of that. Some attorneys will shy away from the informal conference and try to convince you to go straight to the Board of Appeals, because the informal conference can be harmful. I don't know that I necessarily agree with that, but just know that issue exists. Okay. So what the department is basically holding an employer responsible for is convincing the Department of L&I that you have a safety program that is effective in practice. What does that mean? If a worker is observed working in an unsafe manner, do you have a disciplinary program? And is it implemented, fair, and enforced? This is often where I run into a roadblock if I go to an informal conference or a Board of Appeals, is the contractor just isn't doing a good job documenting enforcement. Maybe you are sending people home without pay for a day, or yelling at them verbally, but if you're not documenting it, you can't prove it. And so this is the thing, guys. And as a safety director for a general contractor, I had a really hard time with this because I didn't want to be like the safety cop. I didn't want to issue citations to the employees that I was responsible for. I yelled at a lot of them, but I didn't do a real good job documenting disciplinary action. So even if you do a verbal warning, I call it a written verbal. Document that you verbally spoke to that individual. Hey, take the slack out of your rope. Hey, get your hard hat on. Hey, you're operating a nail gun. You got to get your safety glasses on. Document those verbal warnings. If it happens again, write them up. Issue a written safety violation. If it happens again, maybe send them home for a day without pay. So maybe we're looking at more like a 4 strikes, you're out type program. You can't work them and not pay them, but you can send them home for a day or 2 without pay. And if that doesn't work and they keep breaking the rules, unfortunately, the department would say you got to terminate them. And I know that's expensive. I know nobody really wants to terminate employees and, you know, send an unsafe worker on the next, you know, contractor, but that is what the department will say is, look, if the guy isn't getting it, he's got to be terminated. And then you want to put in your program that if there's a blatant disregard of safety, it could result in immediate termination. If somebody just blatantly disregards your safety program and puts themselves in harm's way, you can terminate immediately. Okay, there we go. I did that in 26 minutes. There, any questions? Hello?
I had to unmute myself. Sorry about that.
No problem.
Here I am. Okay, yeah, there were a few. What is the general starting fine? Is there like a baseline and then it adds on, as you were talking about?
Yes. I don't have exact numbers, guys, because there's so many. It's like if you're driving a Jaguar and you get a speeding ticket, or you're driving a Pinto and you get a speeding ticket, the cost, you know, the price is the same. The fine is the same. It doesn't work that way with L&I because of all those different variables. You know, size of company, severity, probability, good faith, history. So yes, there is a minimum fine. I would say probably the smallest I've ever honestly seen is maybe 500 bucks. But it wouldn't be if it were a fall violation. It would be very unlikely that it would be that low if it had high probability and high severity. I will get I know I have a scale somewhere that a hearings officer gave me recently, and I'll find that, Tracy, and I'll get that over to you.
Yeah, I would love that because I would add that to one of our weekly newsletters that we send out so
Sure.
people could have that information.
Sure.
If you have a safety consultant that you're working with, do you have time when an L&I inspector shows up to call that person without it being misconstrued as you being belligerent?
Absolutely. The department, the compliance officers are used to this. So it's actually my recommendation. If you have a full-time safety person, a safety director or safety manager, or you work with a consultant like Safety Matters, my recommendation is you train your competent persons or your foreman, whoever you're putting in charge of on the project, to ask the compliance officer to wait, because your company policy is to notify your safety director or your safety consultant, and you can hold them for a reasonable time. It's been my experience, a reasonable time is defined as 1 hour. I can't find it in writing anywhere, but every compliance officer that I've ever dealt with will say, I'll wait for up to an hour. While they're waiting, my recommendation is you offer them some coffee, maybe, if you have it, offer for them to review your safety documents, look at your site-specific safety plan, your fall protection plan, your weekly safety meetings, your orientations, your weekly documented inspections, things like that. And keep in mind, guys, even if you're working on a job where a general contractor is doing weekly inspections, that does not relieve you of that requirement. Every employer has to document a weekly inspection. And you would just have to look at your scope of work. In other words, if the electricians are over working on, you know, an electrical panel or something, it's not your responsibility to inspect that area. That would be the electrical sub's responsibility. But make sure you're documenting weekly inspections. If the job is less than a week, then obviously that is not required.
Okay. Does the competent person that you are referring to, do they have to have special training or certification or anything?
So the definition of a competent person is that they basically have experience, knowledge of the standards, training, and authority. Authority meaning they can throw somebody off of a job or write them up for safety violations or, discipline them. And so yes and no. If you have a really experienced roofer, for example, who's been through a ton of fall protection training over the years, and you have documented, fall protection training, and you want to deem him the competent person, he doesn't necessarily have to carry a card that says he has competent person training, but they will ask some very basic questions. So if they go up onto a job and they say, hey, are you the competent person? You say, no, it's Joe over there. And then they go over to Joe and they say, okay, Joe, I understand you're the competent person. When is fall protection required? If Joe says, oh, I don't know, as soon as you're 30 feet in the air, he's not going to be able to really prove that he's competent. So they have these little sheets that they follow to basically prove that the competent person knows the rules, understands when a worker has to be tied off, or when you can or can't go into a confined space or into an unprotected trench, that sort of thing. So we issue cards for competent persons, and we call it competent person fall protection training. And it's obviously much longer than a basic awareness training, just because I think it holds a little bit of teeth if L&I does say, hey, I don't think this guy's competent. Well, he just had he had a brain lapse in memory and didn't realize, when you were asking the questions, he was nervous, or, things like that. So I think it's helpful, but it's not necessarily required.
And just a sidebar for all of our members who are on the call today, in the members Clubhouse, there's a full menu of all of the different training that Safety Matters offers our members at a discounted rate. So please, if you need some training for your people, please head in there and check out the rates, and you can go directly to Safety Matters, tell them you're an RCAW member, and sign up for whatever training that you need. So that's just a really great thing that Jennifer does for all of our members. The last question I have is, what is the warning line system that you mentioned earlier?
So there is an option. It's only on a low sloped roof. So it has to be a 412 pitch or less. Roofers have an exemption where they can come in a minimum of 6 feet and create what is called a warning line. You have to follow the warning line specifications, which you can find in the Washington Administrative Codes. And just so you guys know, the fall protection rules are no longer located in the 155 construction codes. You now have to go to the 800 codes. It's the new unified fall protection rules, and they're in the I think it's WAC WAC 296880. I believe it's either 880 or 890. I'm more than happy to Tracy, I'll email you a copy of these new codes,
Okay.
and you can send them out to anybody who requests it. It states in there that if you're doing roofing work now, which means installing, removing, or stocking roofing materials. So it doesn't apply if an electrician's up on a roof doing working, or a plumber or something. It's only if you're installing, removing, or stocking roofing materials. You can come in 6 feet, build the warning line to certain specifications. It has to have like 200 pounds tensile strength, 16 pounds bursting strength. It has to be at a certain height. It has to be maintained. And if your roofers don't have to go outside of the warning line, no fall protection is required. And there's a potential that you would maybe not even have to have a safety monitor, but in most cases, if you use the warning line system, keep in mind, you also have to provide a safety monitor. That monitor can't do any other work. All they can do is observe the roofing crew while they're working. They can only monitor up to 8 workers at a time. They can't do any other work. They have to be trained as a safety monitor. They have to have a means to call 911. I believe they have to be CPR first aid certified. Don't quote me on that, but I believe they do. And it's a tricky system. You still have to write up a fall protection plan. It's not my favorite option, but believe it or not, if you do have a monitor and you have to go outside the warning line, it's allowed without fall protection. There's been a lot of discussion that this is going to go away and they're no longer going to allow this exemption. But when they moved the construction codes into the 800 codes, it didn't go away. I was kind of surprised, to be honest with you. And here's the other kicker. A lot of GCs will not allow the warning line or the safety monitor system as a means of fall protection. So you need to make sure when you're bidding projects that you double, if you want to use the warning line with the safety monitor, that you double check with the GC and make sure they will allow it.
Very good. Well, thank you so much, Jennifer. That was the last question we have. I just wanted to remind our attendees that our next Lunch and Learn is on February 2nd at 11 a.m. and we're going to have Greg Bjornson from GAS here, his finance director for GAS, talking about all things payments and financing. And then Site Safety Matters will be back on the 16th with some more safety training for us. So this is just really valuable. Please email me if you want any of the handouts that Jennifer has given me, and also this PowerPoint presentation to remind you about anything that you need for your safety program on site. And is there anything else that you want to tell us, Jen?
No, I would just, I don't mean to really like warn people or cause any kind of panic, but obviously with COVID, there's a lot of disgruntled employees that are calling in and complaining that contractors are not, enforcing social distancing, they're not enforcing masks, and whether they're valid complaints or not. L&I is out in full force right now. So even if they come out just for a COVID violation or COVID complaint, just know that they can look at other things. And so I feel like I'm getting a lot more calls these days that L&I is on site, and it is typically being prompted by a COVID complaint. So just make sure that your COVID programs are, current, you're still enforcing masks, social distancing, and just know that, the exposure is a little bit higher right now than normal.
And once again, we've got all of the different COVID information in the Members Clubhouse on our website. So if you need any of that, from COVID plans to just general information, please do log in with your membership password and you can grab any of that information that will be helpful for you.
Okay, is that everything?
I think so, and I have recorded this. And so you can watch for it if you want to rewatch it again in a couple of weeks. It'll pop up on our YouTube channel.
Awesome. Thank you so much, Tracy.
Thank you so much. Have a great day, everyone.
Okay, bye-bye.
Bye-bye.